Kia ora koutou katoa. We'll start off with a karakia and introduce our presenter. So, whakataka te hau ki te uru, whakataka te hau ki te tonga, kia mā kina kina ki uta, kia mā taratara ki tai. E hi ake ana te atakura, he tio, he huka, he hauhu, tihei mauri ora. So tēnā koutou katoa, acknowledging all of you who are joining us today, acknowledging the Indigenous lands that we're all standing from, and acknowledging tangata whenua and mana whenua of the lands that we're broadcasting from today, and also wanting to pay our respects to our elders, the collective good ancestors, past, present and future. Ko Miriam Aho, and I'm part of Tauiwi Caucus of Te Oakiahine National Network Ending Sexual Violence Together. And today we're really grateful and honoured to have another webinar with a sexual violence specialist who is Yvonne Urry, and we'll hand over to Yvonne in a second to introduce herself. Before we get into that, we'll just do a little bit of virtual housekeeping. So as many of you might be familiar with webinars now, thanks also to the pandemic, many of you have been on Zoom. The fundamental difference with a Zoom webinar is that you can't see, you can see us and hear us, we can't see you and hear you, but you can engage with us via the chat. There is a quirk of the chat that if you don't select all attendees and all participants, you'll only message Yvonne and I. If you want to message everyone, then select that all attendees and all participants. So jump in the chat and let us know who you are and where you're from. The other function that you can jump onto is the Q&A, and you can either use the chat or the Q&A box to ask questions as we go, and we'll probably leave all the questions and answers to the end of the session. This session is being recorded, and Yvonne's kindly we'll be making available the slides for after the presentation as well, so you can take notes but don't have to frantically capture everything that is said on the PowerPoint. Apart from that, I don't think I have any other housekeeping to do except for warmly welcome Yvonne to this space and hand over to you, Yvonne.
Kia ora, thanks Miriam. So kia ora koutou katoa, I'm Yvonne Urry, and welcome to my the second webinar in my series for helping people who have an interest in the special sexual violence court support role. So this webinar, the aim of this webinar is to build on the first specialist court support webinar by providing more in-depth and nuanced understandings of survivors' needs in the criminal justice system. I will be highlighting how the challenges inherent in an adversarial justice model to address sexual violence offending impact survivors and thus influences and shapes the court support service and its provision. This webinar can also help court support crisis workers to sort of conceptualise survivors' changing needs for advocacy and support on their journey. And at the end of this webinar, my intention is that you have a deeper understanding of the application of your clinical and advocacy skills when supporting survivors in the context and setting of our criminal justice system. So welcome. That's the content of the webinar. So to get started, just to sort of think about the court support role and why it exists, why we do the work that we do. So it provides specialised sexual violence, trauma-informed advocacy and support that holds survivors' emotional, psychological and practical needs central as they navigate our court system. And this role also helps prepare and support survivors for their journey through the court system by providing tools and coping strategies, advocating for their needs along the way, and being the witness to their experience of the court system. So something that for many people who are coming into this work, there is, of course, we all want to support survivors and advocate for them. We all have that sexual violence trauma-informed practice, but then we've got this court system. And what does that mean? And it's a very, we haven't all gone to law school. We don't necessarily understand all the legalities, and that's part of the role, though, as the more you do your advocacy and support work better, the more you understand what the different hearings mean, especially what they mean for the survivor. Okay, so at every stage through the court process, the criminal justice system is prioritising the defendant's right to a fair trial. So there's no prioritising of the survivor's needs. And while the 2016 two-year court pilot in Whangarei and Auckland District Courts was aimed at reducing wait times for trial and improving judicial training in sexual violence trials, because adversarial justice is anchored in protecting the rights of the defendant at all costs, these changes have not really had a big enough impact to really improve the system for survivors, which is why we have to keep doing this work. Okay, so the officer in charge, they're mandated under the Victim Rights Act 2002 to advise survivors of any outcomes of court hearings. So as you can see in this chart, I've got the different court hearings, after each of these court hearings, the officer in charge has to update the survivor. Every time there are these updates, this can of course be triggering and derailing, as it is a reminder of what happened, as well as a reminder that the defendant is still not taking responsibility, is still not acknowledging what they have done. Something that is really important in your initial contact with the survivor is to have a support plan in place around what their needs might be as they do get updates from these hearings. Okay, so the first, second court appearances. So this is usually when discussions around bail, what the conditions of what the bail release conditions might be, such as having to live at a particular place, having no contact with the survivor, having to report to the police, etc. Now, this is often really upsetting and difficult because they don't feel safe. Okay, even if they're out on bail and the officer in charge might say, but you've got these bail conditions, and if they breach them, you just call us. That's not a guarantee of feeling safe. Okay, so often when they are released on bail, regardless of the conditions, that can be a very unsafe and unsettling and upsetting experience for them. At this stage, while supporting them, it can be really helpful to kind of go through some strategies that they might have in regards to if they are feeling unsafe, because it's an internal, there's this idea of that if there's some external safety put in place, that they'll feel internally safe, and that's not the case. So focusing on ways that they can start to feel a bit safer themselves. The other thing is if they have a family violence process going at the same time, not all of them will, there is funding from the family harm team to the police for getting locks put on their windows and doors and additional safety measures. So there are some external things that can be done, but generally it's more about, especially if that isn't available, is talking with them about feeling safe, how they can feel safe inside themselves, and also addressing real concerns for safety as well. So if, for example, the offender is trying to contact them indirectly through social media, through their friends, they're actually breaching their bail conditions, and that needs to go back to the police. So there are a bunch of things around that which can be kind of addressed along the way. But the key thing is that when they're out on bail, even with bail conditions, that is still no guarantee of safety. Okay, so then usually once they enter a plea of not guilty, it goes through to case review hearings. And these are really just sort of case management meetings between lawyers and judges that sort of highlight any matters that need to be resolved before the trial takes place. It's also where a trial type is elected, so whether it's a jury trial, judge alone trial, or a jury trial or a judge alone trial, but the thing with case review hearings is that there can be multiple case review hearings and all matters won't necessarily get resolved. It's also when the defence lawyer will start to really, start to look at ways to kind of support their client. And that can mean that they might start applying for example, confidential information. So applications for non-play disclosures of personal information about the survivor, which can mean therapy notes or medical notes. I mean, they're not always going to be successful, but you can understand how upsetting that will be for the survivor to be like, well, that has nothing to do with what the offender did to me. Why do they need my therapy notes? But the defence counsel might do that. Also, they might apply for the charges to be dismissed. They might apply for severance. And severance is when there are multiple victims. And what severance means is that the defence counsel will be like, okay, we need to try each separate victim at a different trial. And they'll try, so because obviously with the more victims at one trial, the more we build up a much stronger picture of the offending. So that, so the severance process can also be really distressing, as you can imagine, because it's like, but he's done this to 6 other women. And how can he ask to only have one trial for each? That is legally within their rights to do that. Also, they can make applications regarding concerns about the survivor's veracity or honesty. Again, that's very distressing. Why would they lie about this? They're telling the truth. Why have they come this far? Why would they report? And then applications to cross-examine the survivor about prior sexual experience. Again, a no-brainer. What does that have to do with what he's done to me? So you can see how those case review hearings and things that can come up from that can be, what can be really distressing and upsetting, and you need to be able to be there for them and supportive of them. And also be witness to how unfair it is and how distressing it is and how it's not right that they're allowed to ask to have those things brought into a trial when it has nothing to do with what happened. Okay, so call-overs, these are just sort of pre-trial meetings where the judge and legal counsel get together and just kind of make sure that everything is ready for trial. Now, a sentence indication hearing, sorry, I jumped ahead there. These are another very challenging hearing, because this is when the defendant asks for what kind of sentence they may get if they decide to plead guilty to maybe some of the charges. Okay, so the survivor might be asked to do a victim impact statement for the sentence indication hearing, but these hearings, and yes, it will be taken into consideration, but at the end of the day, the defendant still makes the decision about whether or not they'll choose to plead guilty based on what the sentence indication hearing is. Again, this isn't a genuine remorse or genuine accountability for what they have done. The defendant, again, they're in control of the situation. They get to choose, which minimises and invalidates the survivor's experience. Okay, and then we have the different trial types. So a standby trial, that is not a fixed trial date. So that means that it will go on the list. It's like a wait list. But if the other trials, the fixed trials, go ahead that day, the standby trial won't go ahead. And saying that, a fixed trial is still no guarantee that the trial will go ahead. Anything can happen, can change. There can be so many reasons why a fixed trial won't go ahead. I think the concept of the fixed trial is that it does take priority, but that doesn't mean that it will happen. A judge-alone trial, these usually happen for in regards to indecent assault charges, so category 1 and 2 offences. Also, the defendant can elect to have a judge-alone trial, and this is a trial without a jury. Doesn't always have, often it doesn't always have a Crown prosecutor as the prosecutor, but a police prosecutor. Okay, and for the sentencing and the Court of Appeal hearings, we're going to get onto that a bit further through the webinar. Okay, so as I was doing this webinar, I thought to myself, how can we conceptualize and think about how this role works through the court process? How, what is it that we are doing while all of this is going on? Because the criminal justice process is very procedural, and we are responding to what the survivor's needs are going to be through those procedures. We kind of need to think, well, how do we do that? And what is it that, what are some of the ways that we are taking care of them through that process? Because it's not that we're just turning up to trial and sitting there and patting them on the hands. We are, from the moment that we have been we've got that referral and we're working with them, we are working to prepare and support and take care of them throughout, to walk alongside them through this journey, and to provide that specialised sexual violence trauma-informed care along the way. Because at each point in this journey, as I've already highlighted, there can be so many, there's just the ground is ripe for being re-traumatized and having their experience continuously pushed aside or minimized in favor of the court process and the right of the defendant. Okay, so when we think about, obviously this isn't, it's not so linear. I've tried to sort of highlight how even with a trial, there can be so many things that can change, and how this, for many survivors, they're in the system for a very long time. They're not, it's not cut and dry. And leaving the court support service, that's quite abstracted too, because even after a sentencing, they might be back in contact with you if they get, in regards to parole hearings. So it's not that there's a sudden ending or that you completely disappear, but it's just a way to sort of try and conceptualise how the service works and what it is that we're doing while the survivor's going through the court system. I'm going to talk about the court support wellbeing and support sessions next, but just some of the court-related appointments that is really valuable for you to attend. So there's the Crown and police meetings. The Crown ideally have 2 pre-trial meetings with the survivor. The first one is just an initial meeting to explain the role of the Crown prosecutor, address any issues like around name suppression, explain, that it's a closed court, and just a sort of a rapport building process. And so it's really important to be at those meetings as much as possible, because it not only helps the survivor kind of go, oh, you're the person who's walking alongside me, but there can be things that just because lawyers and police, they have their way, they've got their objectives and the things that they need to talk about, but they're not actually thinking that sometimes the things that they're having to talk about are going to be kind of triggering and upsetting. And you need to be in those meetings, because the survivor, for one, has a witness to their experience. Again, it's very important that they've got that, because then they have that person who can advocate for them or reflect things back to them when they've got concerns. So at those Crown meetings especially, because it will be, oh, you're my lawyer. And they're like, no, I'm actually not your lawyer. I'm there to present your evidence to the court. And they'll be like, oh, and then they'll be like, oh, why does he has a lawyer? And then you sort of explain that. And then this kind of, oh, right, well, what, or am I allowed to talk about what happened? And then it becomes more apparent the further they go down that path, oh, I can't talk about all of my experience, or I have to be, So even though it's very important that they build rapport and good relationships with the Crown, they still have this, I don't have control over this, or at the end of the day, it's the Crown that has, the Crown prosecutor or the legal process itself that has the say in what I can and cannot say, and what will and won't be included in my evidence. So it's, really, and you just need to be there for them through that, so that you are validating how that feels, reflecting back with them that experience. Okay, so closer to the trial date, you've got the court education. This is usually the week before trial, and this is run by the court victim advisors. That will be arranged by the court victim advisors and the officer in charge. Now, often this is the wake-up moment for many survivors. They've been thinking about going to trial, but it's that sort of physical reality of seeing the courtroom or seeing the CCTV room, and it really sort of hits home what they're about to do. Also, so you need you need to be there not only to show, here, this is where I'm going to be sitting, I'm walking alongside you on this journey, but also they often at those court educations, they will actually get really upset and get really worried. Or you might see for the first time that they are actually really dissociative, or they have a panic attack. So there's those sorts, all things which are completely normal for anybody who's about to go to trial. So it's really important to be there so that you are supporting them with that, and to just, recognize that their needs are important, because again, it's still procedural. It's still that court education is about the court process and making sure that they know what the rules are. But so you are there to be like, yes, these are the rules, this is the process, but here I am taking care of you and how you're feeling about this. Okay, and then the other thing, another thing that is really important to be at is if they've done an evidential video and they it's going to be used as evidence in chief in the trial, they're going to need to re-watch that before the trial date. And so obviously this is going to be challenging, because they're going to be watching themselves talk about the abuse that they've experienced in the, and also from from whenever they did the evidential video, which can be a year, 2 years before they, before the trial. So it's very, it's very something that is very common that comes up when they are watching them is, I didn't say that properly, or I don't, they can become very, very, very critical about what they're talking about. They can also, just that of the no-brainer, it's a reminder of what happened, and it takes them back into the feelings and trauma of the abuse. So there's a lot of reasons why they need support when they're watching it. It also is a really good opportunity to start honing in on some of the coping strategies that you've been developing with them, or an opportunity to start developing them. So for example, you can say, right, if you're when you're watching the video and you need to take a break, you need to pause, you need some time out, which is what they're going to need to do at trial. We'll just hit pause and take a break. Like, you can just come back to the present. You don't, so you can also start to reinforce some of that. This is how I can take control. I can step out of this. Here's my support person. Here they are helping me, and I can come. And this is a safer space for me to come back to, from having to think about and talk about my abuse and traumatic experiences. Okay. So there we go. So what I'll do from here is I'm just going to kind of move on to what, when you are starting to do those court preparation and support sessions, I mean, you're not going to be doing, sometimes you're not going to be able to do 3. Sometimes you might even do more than 3. Sometimes you might be doing 5 or 6, depending on what happens after the referral and what the survivor's needs might be. So this is just a rough guide. You don't have to be like, right, there has to be 3. But this is just a way to sort of start to think about what you might be, what your work with the survivor is going to be at each session, and what you're working towards in those preparation and support sessions. So the session 1, or theoretically the contact that you have with them after the referral, you're introducing your role, explaining what it is that, explaining what it is, the support that you're going to be able to provide for the survivor, and how it is, it's about taking care of their emotionally and psychologically, and that you're the person that they can check in with if they are freaking out, or they're overwhelmed, or they've just got, or they've had an update from the court victim advisor, and now they're freaking out about what it means, and they're worried, and they've had a panic attack. So that's sort of the initial contact that you have with them, and the plans that you put in place. It's also important that you have permission to liaise with the officer in charge, or the court victim advisor, or other professionals that they're involved with when relevant, because for you to be able to do your work well, you do need to have build a relationship with the officer in charge, because that way, I mean, that's going to just be easier, and they also know what your role is and the support you're providing for the survivor, but also so that you are getting those court updates as well. So you have that, here's this, here's something the survivor's had an update. It was a sentence indication hearing. We're going to be, going, why isn't, how come he gets to choose to pick up it? So you know what you need. It's that, here's some work that needs to happen that I need to do. So session 2 is ideally 6 weeks to a month before the trial. Again, this doesn't always happen. Sometimes you might only meet the survivor the week before the trial. But if we've got this, they've come in at the very beginning and things are moving quite well, you want to meet with them 6 weeks to a month before the trial. And this is to really start, because as the trial date gets closer, they are going to be, obviously really thinking a lot more about what happened. They're going to be worried, they're going to be scared, they're going to be anxious, all of that. They also might be thinking, I don't want to do this anymore. I've been waiting for a year, I haven't had to think about it, and now I'm having to think about it again and I don't want to, and I'm scared. So yeah, so that session is really important for addressing whatever is going on for them, and to create that trial support plan as well. Emotionally prepare them for the trial and sort of think about what their needs might be through evidence in chief, what coping strategies are going to be useful for them in the court setting, and what might be some of the challenges that arise during evidence in chief. So for example, if they are already quite prone to having panic attacks, that could happen during evidence in chief. So when they start to identify that, what can they do? I mean, pretty much the default is taking a break, but it's being able to kind of create that scaffolding and those reminders that when you start to feel those, when you feel that coming on, you can stop. And also very simple grounding exercises for in a courtroom setting, which can be as simple as focusing on the breath, slowly taking sips of water, having something tactile in their hands that they're holding that they can, like thinking putty or a special piece of jewelry or tonga. Okay, so session 3, which is again the week before the trial.
I'll just pause you a second because there's I think an important question, clarifying question that has popped through that might help people grasp some other pieces, which is just if you could explain what evidence in chief is.
Oh, evidence in chief. So evidence in chief, that is that's pretty much when the survivor is called up to the courtroom to go over their evidence. So that's what evidence in chief means. So pretty much evidence in chief means the survivor having to deal with the lawyer, having to give their evidence and talk to the lawyers in the court. Yeah, I hope that's so that's what evidence in chief means. Yeah. Yeah. That good? Okay. Okay, so the week isn't actually, that's actually another really good point. And with this role is getting used to what legal terminology and what it means. And I have actually provided a resource at the end, which you can link to, which will explain what some of the terms mean as well. Okay, so the session 3, which is the week before the trial, you've got your support plan finalised. If the media are attending, now the media can make applications to the judge to attend trials and report on them. They can't identify the survivor because the survivor has permanent name suppression, but they might ask if they can play the audio of the survivor's evidence in the news and just change the tone of it or distort it. The survivor doesn't have to agree to that. But the survivor has no choice as to whether or not the media are there. So that, of course, can be quite difficult. I guess just those reminders that they can't, reassurance, they can't identify you, they cannot name you, there won't be any pictures of you. But any kind of media reporting on a trial is also really challenging and difficult too, because it's another way that their experience is being, and their narrative is being taken away from them and kind of told by somebody else, or constricted or changed. So, and misrepresent, it's another misrepresentation, or not a full way for them, for their experience to be held in a way which feels, feels that it's centered on their experience and centered on their feelings and their needs. It can just be, obviously it's media, so it will be more about the details and the sensationalization of it, or the fact that it's clickbait, and it will, So if the media are attending, then just be aware of that as well. There's that extra, and that they might. You can also say to them, I know you're going to want to probably read the media after. Maybe you're going to, but just remember, if you do check the news, to just remember that it's just another, how it's reported is still not going to be, it might not be in any way representative or accurate about what you're feeling and what you're experiencing. So so advocate for any needs that might come for the week before trial. So for example, you might go to the court education and they have a panic attack and they realise, I can't be in the courtroom with a screen, I just can't do it. And so you can do an emergency application for CC, for them to give evidence in the closed circuit TV room. Again, that's not a guarantee, but it's definitely worth anything that you can do to best support what their needs are going to be. You just do it. Okay, and you also revisit the emotional preparation and coping strategies that you've covered in the second session. And again, these are ideal. You might be doing all of this, doing session 1 and session 2, or addressing all of those needs in that week before the trial, or even the morning of the trial. Okay, so preparing them to give evidence. So something that's really important is because often survivors are like, I'm not going to know the answers and I'm going to get it wrong. You need to remind them that they already have the answers. It's their experience. They're the expert on their experience. They already have them. Obviously address their concerns about getting things wrong and things not going well, because that's what they're worried, because they've come this far. Of course, they want a guilty verdict or for the offender to be held accountable. But you just have to say, well, we've got no control over that, but what you do have control over is you are the authority on your experience. Also, it's really important to explain your role while they're giving evidence. For example, you are there they can't talk to you while they're giving evidence, they can't acknowledge you. The only time that they can talk to you is if they take a break. So they were, what are you doing there? Like, well, I'm paying attention to everything that is happening. I'm paying close attention to what your needs might be. I am there to keep an eye on everything that is happening and that you're going through. And I'm there for you in the breaks to address anything that is coming up for you in that process. It's good to sort of think about any kind of in court-specific challenges. So if they are giving evidence in the courtroom, they might get, obviously the defendant is going to be sitting usually 2 or 3 feet away from them behind a screen, unless they don't have a screen. And while they might be like, I'll be fine, they'll be behind a screen, but at the same time, the defendant is behind a screen, but they can still see them, but they can't see them. But they might suddenly realise, well, actually, they get into the courtroom and they start to feel quite panicky. So what are you going to do if that happens? It's okay if you go into the courtroom and you need to stop straight away and leave again. It's just everything that, whatever it is that you need, we're going to address it. Okay, we're going to take care of it. And the other thing is, of course, when they go into the courtroom and sit down and they can see the jury, and that, there's a whole lot of different things that they're trying to manage and negotiate when they go into the courtroom. It can be helpful to say, look, sometimes it's really good just to focus on looking at the Crown Prosecutor, or sometimes if you move your chair a little bit and you look away a little bit and just focus on just do whatever it is. Focus on whatever it is that you need so that you're not being feeling overwhelmed by everything else in the courtroom. And if you are feeling overwhelmed, you do need to stop, and we'll take a break. Okay. It's good to go over those things when you're preparing them for the trial, just so that they have an idea of what they are. So if they do feel that way, it's normalized. Oh, right, of course, yeah. I went over this in my prep sessions. It's quite normal to feel this way. And here are some coping strategies that I can use. Oh, okay, that's right. And I have to remind myself that even though there's all these different things going on, I'm actually safe and I'm being taken care of. So closed circuit TV specific challenge, room specific challenges. Okay, so often the screen will just suddenly turn on. There'll be no warning, and here's the judge and there's the lawyers, and so prepare them for that. So yeah, I often feel like they should have a beautiful little pulsating, not pulsation, but just some kind of like a pink light that pops up that tells you that they're about to turn the screen on to the courtroom. The other thing about the CCTV room is that there will be a court support officer in the room at the same time. And these rooms can be quite small. And so it's this other stranger who's sitting in the room with them while they have to talk about this very private and traumatic and difficult experience. So it's good to give them the heads up about that, and also where you'll be sitting in the CCTV room, which is often to the side and behind. But if they are, it can be really helpful. Say, for example, they're not comfortable with the court support officer, and sometimes you will get, especially for women, if the court support officer is a male, they might not be comfortable with that. But we can, usually the victim advisors at the court are really good at going, oh, we'll make sure that it's a woman, and they'll go over that during the court education process. But sometimes that might get missed. And if it is someone they're not comfortable with, then you can say, oh, the survivor isn't comfortable with this court support officer. Is there somebody else that we could bring in? Again, no guarantee, but it's always good to just keep that in mind. And also to remind them what they have control of while they're giving evidence, okay? They know their experience. They can ask for questions to be, if they don't understand something, it's within their right to ask them to be repeated or rephrased. They can stop. Stopping, taking a break is how they take care of themselves. And it's a way for them to say, this isn't okay, and I need something for myself, I need some space, and I'm going to, and I need to get out of the situation so that I can express my feelings. Yeah. And one of the so when it comes to cross-examination, that's pretty much what they're always worried about, and what is the defence counsel going to ask? They're going to be trick questions. Are they going to trip me up? So the key thing to remember, again, their job is to sort of present an alternative explanation, but you just come back to what you know, your experience. They might present it, put it to you in a way which makes it sound different, and you just come back to what you know. And it's very it's tiring to have can feel like gaslighting to have someone. And they often they're not really listening to your answers, or it's not like your answers are being taken seriously, but you just have to keep coming back to your truth. And whenever you start to feel, that you're getting angry and upset and derailed, which is all incredibly normal, it's so normal to feel that way, give yourself permission to step out and have some space. And just remind yourself, this is their job. This is what they do. But I still have all the answers. But I have permission to attend to my feelings and what my needs are going to be in that process. Okay. So during the support process and trial, we are actually, court support people are wearing two hats. So the first hat is that we're responsive and supportive of their needs throughout, but we also need to adhere to the legalities so that anything that we are doing to support the survivor doesn't jeopardize the trial, okay? And the key thing is that survivors are going to want to talk about the evidence, especially during cross-examination. They're going to, when they take a break and they come into that room with you outside of the court, they are going to be like, oh, I can't believe he's talking about this. And what does that have to do with anything? Really, really normal, okay? But legally, they're not allowed to talk about it with you, because it can be construed as coaching them or helping them with their answers, which of course it isn't. So you just have to go through these gentle reminders. Hey, I know how upsetting this is. I can see how frustrating this is. I can see how unfair this is. You're finding this. But remember, we can't talk about your evidence. Let's just talk about how you're feeling and what you're going through and how you have every right to be feeling this way. Okay? Really important. Because you don't want to risk a mistrial. You don't want to risk anything like that. But you can still attend to how they're feeling and their experience. Okay? Another thing that is very common is there might be other witnesses other people giving evidence in the trial, the witnesses, who they're actually very close to. It could be their family, it could be their partner, it could be their best friend. And the really difficult thing is that while they're giving evidence, they're under cross-examination, they're not allowed to talk to them, okay? Which is, so you just need to remind them of that as well. And often they'll be at the courtroom with you anyway, but their other witnesses might be milling around. So it's just really important to gently remind them, if we bump into them or you see them, I know you're going to want to, but you can't, okay? And you can't text them or call them. Yeah, it's really hard, really, really hard. But also remind them that it's temporary, and these are just rules. These are just the rules of the court. Here we are at the court, and these are the rules. Okay, and in the real world, you would just actually be able to go and talk to your best friend about what you've just been through. But with these rules, you just have to wait. Okay, so once they finish giving evidence and they're waiting for the verdict, this is actually a really difficult time where you need to start really thinking about taking care of their needs again, because they're in limbo. Arrange to get updates from the OC about what's happening in the trial, and just also keep in mind that anything can happen after the survivor's given evidence. So there could be a mistrial, things could go wrong, but you're not going to talk about that with them, but you just need to keep that in mind. And you need to be checking in with them regularly, having a support plan after they've given evidence. Often I would find that these would be, just check-in phone calls every day, usually when there's been an update from the OC about what's happening in the trial. Sometimes it's text messages, it's always up to them. But yeah, it's a very difficult time. They've just come away from being cross-examined and having a really, really traumatic experience. So they can have heightened distress. They can be full of self-doubt. They're going to be going over what they did, over how they didn't feel that they could answer their questions properly during cross-examination, really ruminating on that, worried about the jurors not believing them. So during this time, you need to sort of remind them that they did well. Again, they don't have any control over the jurors and how they think. Also, that whatever the verdict will be, of course, it can't be a direct reflection on the survivor's experience, because the full experience wasn't presented at trial. So how can it be how can whatever verdict, especially if it's not guilty verdict, how can that be reached without all the information? And that's not their fault. That's not their fault. That's just because that the rules of the criminal justice system are really, it's like that the rules keep things very narrow, whereas their experience is so much bigger than that. So yeah, just remind them of that it can't completely hold and take care of the experience. And also provide space for them to vent about their experience of cross-examination in the defence counsel. You'll have through your rapport building and your relationship, you'll have a pretty fair idea of what that might involve. For some of them, they might need humour might be really helpful. They might want to take the mickey out of them. Whatever, that's saying, if we're not, if we don't laugh, we're crying, if we're not crying, we're laughing, whatever they might need, okay, to help sort of vent that event and talk about, and kind of start to process their experience of being cross-examined. So once the verdict comes through, there's all these different support processes to keep in mind. Obviously, with a guilty verdict, you've got the police and the court stuff like, yeah, he was found guilty, that doesn't mean that it's super positive. It can, remember, the survivors just still had to go through that whole trial process. Maybe had to wait 2 years to get to trial. Doesn't, just because there's a guilty verdict still doesn't mean the survivor feels that the person has taken any responsibility for the harm that they've caused. I mean, they just had to go through all of that to try and get even the slightest bit of acknowledgement for a guilty verdict, which has gone through a process which still hasn't completely held or represented their experience and the harm they've caused. So just keep that in mind. There'll be, also, you need offer at this time to help with their victim impact statement, and then obviously preparation for sentencing, which we'll talk about next. With a not guilty verdict, always heartbreak. And this is, you can understand why people get really excited about guilty verdicts, because the alternative is are not guilty. So you need to obviously support them with your feelings, give them space to grieve and rage, address any safety concerns as well that might come up. And I always do a follow-up session after. I check in with them the next day anyway, via phone, or I see them face to face, but also provide option for additional follow-up sessions, just to help them process their experience. And because you can imagine how deeply, well, you all know how deeply disappointing and distressing that is. So with a mistrial or a hung jury, so that's when a trial cannot reach a conclusion and there is the possibility of a retrial. So again, this can happen any time after they've been cross-examined, and then, oh gosh, now there's the prospect that I might have to go and do this all over again. So it's important to explore they don't have to make a decision about that, to explore their thoughts and feelings around that. And then if the Crown would like to think it's worth going back for a trial, it's going to be their decision, but they will take into consideration the survivor's needs. Then you're able to advocate for what it is that they want. But you can, and then of course you have appeals, but we'll get onto that as well. Okay, so a trial aborted. This is terrible terminology, but the judge has made the decision that the trial cannot continue. There's it's a similar kind of experience to a not guilty verdict in regards to not feeling believed, that they've come all this way, and there's going to be no opportunity at all for justice. So this is, and there's no option for them to appeal. They still, again, have no control over this. And just remember that at every single point in the criminal justice process, they don't get to make any decisions. It's all made by somebody else. The whole process is dictated by legal professionals, by the legal process, and by the defendant. So again, you'd go through similar support as you would post a not guilty verdict. Okay. So writing victim impact statements. So this is the one thing where they get to just talk about their experience and how it's impacted them. However, because it is still considered a legal document, it's still got rules. So, for example, they're not allowed to tell the judge what they would like to have happen to the defendant. They're also not allowed to directly address the defendant. So, but of course, because it is the one time where they get to talk about their experience and their feelings, when you're helping them write this, you want to be able to weave in their need to talk, their needs to actually address the defendant and talk about what they would like to see happen. So you can do that in a way which is adheres to the rules of the victim impact statement. I mean, again, for example, you might, they might say something like, the defendant, you need to get help. You need to get this sorted out. You can't do this to other people anymore. So you can kind of weave that in, like, because of what, you know, because of what the defendant has done to me, I worry that they will do it to somebody else. I worry because I feel like they need help too, so that they don't do this again, like therapy or counselling, because I just don't want this to happen to somebody else. Okay, or something like I don't feel like a prison sentence is going to fix this or help this. So yeah, I don't, you know, even regardless of the sentencing outcome, I still worry that this isn't going to help them and address the harm that they have caused. Yeah. So there's I have included there's a link to a guide in writing victim impact statements at the end of this webinar on the resources page. So they're very thorough and very comprehensive. I guess the thing is, defence counsels can challenge victim impact statements. So I never had this happen personally, but survivors have had them come back, especially when I'm not trying to say that we're the experts in writing victim impact statements either, because it's still also really important that their voice is part of that. But it's just that we can help them with their victim impact statements, so that everything that they need is there, that we're able to work with the rules of the victim impact statements so that we can include as much of their voice as possible. Yeah, because it's kind of, as you can imagine, it's awful when the defence counsel read it and it gets challenged and it comes back and it's been got notes written all over it by the defence counsel. And again, it's another experience of having being told what they can and can't say. So if we do it with them, and we're able to weave it in a way which keeps it all very adhering to those victim impact statement guides, and then it's just, yeah, and it can be done. There are ways that we can help the survivor and sort of phrase some of the things that they're feeling and wanting in a way that aren't going to be, that can't be kind of seen as legally incorrect. Yeah. Okay. Talked more about that one. But yeah, there are, I mean, in many ways, I love writing victim impact. It's something that it might not be everybody's thing, but it was something that I was very passionate about when I was working with survivors. Okay, there's some practicalities there. They need to be handed in at least 2 weeks before the sentencing. You need to kind of talk, if they are going to go, they don't have to go to the sentencing. This is the other thing. They can have their victim impact statement read out by you or the Crown or even the victim advisor, but they don't have to be at the sentencing. Okay, so, and if they do come to the sentencing, they have the option that they can read it out with you standing with them, or you can read it out, or again, the Crown prosecutor can read it out. So there's so many different options. And it doesn't have to be read out at all. So it can just be read to the judge. Of course, you do need to say that the defendant is allowed to read it. Okay, but that's okay. I mean, if it's, it's actually for them, it's like, well, this is the time where I get to really tell them. And also the other thing, which is really important, is to talk about how going through the court system has impacted them. So in the victim impact statement, it's very important for that to be heard too. So, e.g., going through the court process has really impacted my life. I felt like my life has been on hold. I haven't felt like I can get on with things. I've had these kind of constant reminders of what happened when my therapist and I are working so hard to helping me process this and move on with my life and process that trauma. And the court process has really set me back. So yeah, that's a good thing to do. Always good to include how the court process has impacted their life as well. Right. Okay, so preparation for sentencing. So again, there's this idea that sentencing's a great, yeah, they gets to get sentenced and he gets his prison term. No, not at all. Yeah, for some people it might be like that, but very rarely was that what survivors were feeling. How sentencings are in an open court. The survivor's going to see the defendant probably for the first time since the offence happened. And their support and the offenders support people. Remember, the support people can write letters to the judge in support of the defendant, and those can be read out. They can talk about, and those letters, wow, they can say things like, he's a great person and his whole life has been derailed by what the survivor has, put us. So, okay, hopefully some judges are much more better at using their discretion in regards to what they will read out in the court, but just be aware that there can be that, those letters of support. Well, even the presence of the support people as well. And they're not pleasant. Sentencings are not safe. The trial affords a whole lot more safety because at least the court is closed. The defendant supporters can't wander in, and you've got all of these. You've got the victim advisor area to retreat to, depending on which court. I mean, that's Auckland District Court and Manukau District Court, and the courts in Auckland. I'm sure that there are victim advisor areas in other courts around Aotearoa, but yes, but there's none of that for the sentencing. There's all sorts of people milling around. There's multiple hearings happening in that courtroom at the same time. So there'll be loads of strangers. Anybody could be sitting in during that sentencing, people unrelated to the sentencing. The defence lawyer is going to say very supportive words about the defendant, about how remorseful they are. They haven't shown any remorse at all, but they'll be like, they've been remorseful and they've gone and done some community work, or their job has been really impacted and now they're financially really struggling. It's had a huge toll on their mental health. They suffer from depression. So there's all these things that the defence lawyer is going to say, and the survivor's going to be going, why is this about him? Shouldn't be about him. Absolutely. But again, it's another aspect of our adversarial justice model, which is premises and prioritises the needs of the defendant. The other thing to keep in mind is when the judge hands out the sentence, they will talk about the details of the abuse. Very triggering, very traumatizing. Also, on the day the sentencing might not go ahead, it's always to do with usually some administrative thing that we need to get a psychologist report from probation. Just be prepared for that as well. So when you're preparing the survivors, say, yes, we've got the sentencing and we're going, but sometimes they can get delayed. Okay, again, that's really frustrating. It's like, well, they should have everything sorted out and ready. And so you'll also learn to be using some of your breathing, your own breathing strategies and skills as well. Also, the sentence that is handed out often does not reflect the seriousness and harm of what they've experienced. Again, it's another way that it's minimised and played down. Even though a prison sentence doesn't resolve it, often it's like, so they've got 3 years. Or they've got 2 years of, they've got a 2-year non-custodial sentence. So they can just go home with an electronic bracelet around the ankle. How does that? Their lives are still nowhere near, their life has not been impacted in anywhere or impaired in any way as much as my life has because of what they've done. So just keep that in mind as well. Okay. So when you're supporting them, so you fully explore everything that we've just talked about. You need a support plan, a very robust one, okay, because things can change very quickly, obviously. And it's really important if there is an option for the survivor to view the sentencing via closed circuit TV, that you make an application for that, because that way they just get to watch it from the safety of a closed circuit TV. Okay, you can talk to the officer in charge about that. Okay, good ideas to keep in mind for the support plan for the day is, who's reading it. who's reading out the victim impact statement, if they change their mind at any time, where they can leave the courtroom, and that you are there paying attention to everything that is going on for them, and to say, look, my priority is that your well-being and your safety. So if things change, then we leave, and that's okay. Right? Also, if there is there are some issues with the defendant support people, do alert the court security staff, okay, because they can come to the sentencing and they can stand in the back there and just keep an eye on things and make sure that people stay in line. Okay. Alrighty. So appeals, I've only got 1 minute left. Just remember, at any point in time after a guilty verdict or a sentence, the defendant has 28 days to appeal the outcome. So it's really advisable never to provide this false expectation that the court process is going to end after a guilty verdict or sentencing. You need to focus on the positives of their experience so far. They survived a cross-examination. They have been strong all the way this way through. At every point, they have been saying, no, I'm holding you accountable. What you did was wrong. Okay? So part of this role is sort of climatizing the survivor to that roller coaster ride. So if they know there is a potential for an appeal, then they can prepare for another roller coaster ride with you. Okay? So with Court of Appeal hearings, they tend to happen around if it's accepted, usually within 3 months of that application. So with appealing guilty verdicts, there's the potential for a retrial. So you're going to have to explore, again, it will be up to the Crown, but it's going to be exploring the possibility with the survivor about how they're going to feel about going back and doing it all over again. And appealing of a sentencing, so there's a potential for the Defence Counsel to ask for a lesser sentence or a discharge without conviction. Okay. The discharge without conviction is when, if they're able to sort of, especially if it's already quite a low sentence, if it's already at the sort of 3-year mark, and the Defence Counsel can argue that if the defendant has a conviction, it's going to seriously impair their well-being in their future. Okay, and with that, I will end. So there's just some appendices there for you, just to that relate to the earlier slides in regards to Crown meetings and court hearings. And then here are some resources for you. And here is my contact.
Nā mihi, Yvonne. I was sitting there absorbing your presentation and really getting that sense of how complex and detailed actually the role of the court support worker is, and both for the survivor, and thinking of my own experience of supporting survivors in court, and not as often as you have. I did a few when I was in a crisis support worker role, and really you described it so well, of that roller coaster of different stages, and really wished I had these 2 presentations back then, even though I had the fortune of being able to talk to you directly back then. I think it's being able to go back and remind myself of all the details, because there's so much information. So thank you for sharing your wisdom with us. People have stayed glued on, even though we're getting to the end of the time, but it looks like people are really engaged and interested, and that's come through. So we do have quite a few questions. So I thought I would tie up some quick factual questions of just how long does it take usually to get a verdict? Is there a set time, or?
So it depends on how many witnesses there are in a trial. So say, for example, if there is the survivor and maybe a couple of witnesses, maybe hopefully it would be a week. But because the timing is so unpredictable, because there can be legal arguments, there can be delays, jurors can go AWOL, and then they have to make decisions about whether or not to continue with only 11 jurors. And also, once the jurors go out to deliberate, sometimes they can really struggle to reach a unanimous verdict. So, yeah, any idea? I mean, I'm going to roughly generalize and say, hopefully by the end of the week of a trial where there's only maybe 3 witnesses, if you're looking at a trial where there are maybe, 9, 10, 15, maybe 2 weeks. But I think the key thing to remember is that ideally it's over by the end of the week, but that doesn't always happen. Okay, so this is the other sort of thing to take on in this work, is that you as a worker have to be able to deal with the fact that everything is unpredictable. So
and contain that for the survivor on the journey, being able to hold that unpredictability. And what I really noticed as you're talking, it's holding the unpredictability and the structure of the system, and finding spaces to create choice and agency for the survivors seems like an essential part of this role.
It is. And also, and you are the, you're the person that they are talking to through the whole process. You're their touchstone to everything that's going on. You're the person you're the container for what they're feeling and what they're, So part of that is, what's up with it? Well, look at these delays. God. But I often describe the court process as like the worst airport you've ever, or the worst overseas trip. Your luggage goes missing, the train gets delayed. The plane takes off and then lands again because there's the plane, and then you have to. So it's like the worst, and then you actually think, why did I even bother? Why did I even start this journey? Why did I book my tickets? And
cool.
it can, cool.
Just in terms of survivors where English isn't their first language, what's in place in terms of interpreters and translators? How does that work?
Okay, so that is something that the Crown and the police will arrange. They will always have interpreters. Okay, so that's nothing that you have to organise or worry about. Also, really important to build up a good relationship with the officer in charge, because the work that you do, the support that you do, you are also potentially going to need an interpreter as well. So what I would do is I would arrange with the OC to be able to utilize the interpreter for the support work I did. Okay, so there's no. I haven't done the work for a little while, but there was no funding for this role to bring in interpreters. So that was we used the interpreters that the police used.
Okay.
Yeah, I don't know if the police are going to appreciate me saying that, because they're probably like, oh God, oh no, because it's I know that we don't have enough interpreters, and they're definitely we're not well resourced. It shouldn't be like that. It should be much better. It's something to advocate for, but wherever you can, But they're in place for the trial. They're in place for any police meetings and Crown meetings. So again, like another reason why it's really important that you go to those Crown meetings and police meetings and court educations too. Okay.
Great, thank you. What would some of the reasons be for a trial being aborted? I'm wondering, there might be a follow-up webinar needed with some legal folk, but if you might want to give a quick answer to that.
So there's many things that can. Usually it's because there's issues with the evidence, okay, or there's something that comes up along the way that that means that the veracity being that the survivor is believable, okay, that the jury can make a verdict based on this information that's come to hand, because it changes the script or the narrative that the prosecution is presenting to the court. So anything that is going to and it can be okay. So let me just tell you. I'll give you an example. So, and this sadly does sometimes happen with young people. So there has been a text exchange or a Facebook Messenger exchange between the young person and the defendant. And the young person has deleted all those messages and told the police that they don't exist. and then it has come to light that they do exist. And those messages, even though there's a perfectly good reasons why that young person was trying to sort things out with the defendant, because maybe it was a peer, and but of course the young person's like, oh, that's going to make me look bad, so they delete them. But then that will compromise the trial.
Yes.
So the defence counsel was able to say, wow, look at these. It says that they lied in their evidence. So yeah, anything that basically puts to question the veracity of the complainant and the evidence and what has been put in the prosecutor's case. Yeah.
Great.
Oh, and also one other thing as well, if for example, during the evidence in chief, so in the courtroom, if something comes up during that, if the survivor remembers something new or something which can happen, and then the defence counsel can say, well, they didn't talk about that in the... So, yeah, I think another webinar might be in order.
Yeah, we'll keep going on this series, absolutely. The evidence part, it ties in well with the next question, which does the survivor have to wait around
after
they give evidence?
No.
So that's their job done.
Job done. And they want to, for many of them, they want to get out of there anyway. Sometimes you will have survivors who might want to watch the rest of the trial, and legally they are allowed to do that. But just also, again, you want to prepare them for that. Okay, so you're going to see, you're going to see the defendant. You're going to have to hear more of the defence counsel's questioning and listen to more of, and again, you're not going to have any control over what is being said and how you're being portrayed. So really cover off what that might feel like. I never had a survivor want to stay and watch this. Yeah. Okay. I've had some think about it, but then, yeah.
And this next question, which I'll tie in with just a statement. So someone was asking, are there times the survivors don't receive this support? And just for those who aren't familiar to the sexual violence sector, within the specialist sexual violence sector, there's currently a slow rollout of this service across the country. So it's gone from being in very few locations to being expanded to more. So it's a developing space, which is really exciting. And in that developing space, we're still not, we don't have an equivalent service for children. But the question here is, does the evidence in chief process apply for child survivors, or is this only applying for adult survivors?
It applies to children as well. So, yes. I mean, so children do have to go to trial and give evidence. It's always in closed circuit TV, okay? So they're never in the courtroom. Yeah.
So there are a few differences, but the process is pretty similar. And the similar, I suppose it's kind of covered off, but does the defendant get a choice if it's a jury or a judge when it's a child?
Yes, they do. They do have that choice. However, with judge alone trials, a lot of the time with child complainants, it will go to judge alone, usually because charges against children have a lesser, like they might be an indecent assault charge, and indecent assault charges are more likely to go to judge alone because they're considered category 1 and 2, which is lesser charges, which is of course just awful.
And that's our question. So I just wanted to mention a couple of comments. Someone says, perfect description, Yvonne. Thank you for the great presentation. Really excellent presentation, Yvonne. This is such a complex role, and this sort of expert training is vital to increase the support for survivors. So thank you. And that ties in well with my thanking you for today and us wrapping up today's webinar. It's been enriching. It's been dense of information and that kind of continuous advocacy space, and really finding that skill of holding the survivors' needs centre to our practice is really what came really strongly through your own practice and your ethics and how you orientate yourself within the system. So I'm really grateful that you were able to offer this webinar to the sector. So thank you very much. And so we'll thank everyone. I have reminded everyone in the chat that there is support there out for us as well as professionals. If I've reminded it in the chat throughout the session. These trainings can hit us in all sorts of ways, and if there's a need to talk more, hopefully people are engaged in supervision, but also there's safe to talk there if anyone needs to have a chat about anything that this session might have brought up. It's absolutely normal. We're human, even though we work in this space or we are professionals. And to close us off and farewell us on this journey for today, I'll just conclude with a karakia, which is unihia, unihia, unihia ki te uru tapanui, kia wātea kia māma te nākau te tinana, te wairoa i te ara takata, ko ia rā e rongo whakairia ake ki runga, kia tīna, tīna, hui e, tae ki e. Go well, everyone. Have a wonderful rest of your Friday.